rise.
Yes, Mr. Fay.
The proposition I was putting just before lunch was that paragraph 323 and 314 do not involve or invite a reopening of the issue of need. My Lord, that's clear in my submission also from EN1 when considered as a whole. And if I can ask Lordship to take up the judgment of Mr. Justice Holgate for Bundle 1, starting at 128. And at page 139 in particular.
If you could give us the paragraph number.
And paragraph 58. And he said, the government's policy on energy infrastructure development in part 2 of EN1 is critical to understanding the policies on need on which key parts of this challenge have focused. And in my submission, he was right to do that. And can I ask then for EN1 to be taken up, which is in the supplementary bundle at tab 2. He referred to a number of references within Part 2, and I was only going to just draw Your Lordship's attention to a few rather than them all. And 224 on page 21. Four lines down makes it clear that the role of the planning system is to provide a framework which permits the construction of whatever government and players in the market responding to rules, incentives, or signals from government have identified as the types of infrastructure we need in the places where it's acceptable in planning terms. And that theme is picked up again at 2219 on page 24. Four lines down. Four lines down. While the government may choose to influence developers in one way or another to propose to build particular types of infrastructure, it remains a matter for the market to decide where and how to build, as market mechanisms will deliver the required infrastructure most efficiently. And then refers to, in the final sentence, other incentives and rules or signals. And then at 3.3.18, on page 33, it makes it clear what the status of the projections in these passages are. Not possible to make an accurate prediction of the size and shape of demand for electricity in 2025. In order to get a sense of the possible scale of future demand to 2025, one possible starting point provided by the UEP of 2010. And to the last sentence, the projections do not reflect the desired or preferred outcome for the government in relation to the need for additional electricity generating capacity or the types of electricity generation required. And on the next page or two, there are some illustrations of projections. 3321, having referred to some projections in the earlier passages. No such projections can be definitive. They illustrate the scale of the challenge. 3324, about 7 lines down, further breakdown of this figure to illustrate the scale of the challenge. And then, importantly, 3324.
Sorry, you've just been at 3324, haven't you?
Yes, and then 3324. Sorry, that was 3321.
Oh, sorry.
3324 concludes on this section which has been looking at some of the projections that have led to the NPS. It's not the government's intention in presenting the above figures to set targets or limits on any new generating infrastructure to be consented in accordance with the energy NPSs. It's not the role to deliver specific amounts of generating capacity for each technology type. Government has other mechanisms to influence the current delivery of a secure, low-carbon, affordable electricity mix. Indeed, the aim of the Electricity Market Reform Project is to review the role of the variety of government interventions within the electricity market. And just as a side note, the Electricity Market Reform Project led to the Energy Act 2013 with a mechanism for contracts which take account of carbon.
These paragraphs are all under the heading at 32, the urgency of the need for new electricity capacity
Yes.
and what's needed in 20 to 2050 and certainly in the next 10 to 15 years, is it?
Yes.
And that's what it's assessing.
That's what it's assessing, and it's intended to be illustrative and firmly not to be identifying any particular target or limit on the new generating infrastructure to be consented. And that is, of course, reiterated in the passage that I did take your lordships to before lunch on page 28 at 312. Which I won't read out again, but reiterates the targets or limits message. So my submission, it would be inconsistent with the remainder of EN1. Those are some of the passages. The judge refers to some others which are of that nature. To construe 314 and or 323 as involving or requiring the involvement of a reopening of the issue of whether there is a need for a particular energy project, including CCR fossil fuel generating stations.
So if the government were to take the view that we've got enough fossil fuel generation, you say that the way that the government gives effect to that is to change the NPS.
Yes.
And in effect, that's the only way.
Yes, and it can suspend the NPS pending its consideration of that under sections 11 and 108 of the Planning Act. And it can do that during the course of an examination as that suspending power.
Is it an appropriate time to pick up the point about the related point about section 104.7 that I was canvassing with Mr. Jones, i.e. the question of government thinking or policy or generally having matured or changed, and that coming in through the section 104.7 balance?
Well, that would be subject to the issue of the merits of the policy not being challenged.
Yeah, but leave that, assuming that was all right. So, for example, government policy on climate change might change. Could that affect the section 104.7 balance? And then that comes in under 104.3.
Certainly, looking at the adverse impact side of the equation, as happened in this case, the Secretary of State did look at the question as to whether the amendment to the Climate Change Act in 2019 would make a difference and justify taking a different view. That's at 5.9 of the decision letter. So it is open to the Secretary of State to do that, so long as it doesn't impinge upon the merits of policy, and it doesn't preclude necessarily persons making that representation, but it would be subject to the limitations that may operate under the various preclusive provisions about challenge to the merits of policy, which are not only the one that Mr. Jones referred to, but they're littered throughout at various stages of the decision-making process. Two other points, if I may, on this ground one. The first is the implications of the appellant's approach, because it is clear from the appellant's skeleton argument, for example, at 28.2a, I don't ask the Lordships to look that up, that their approach would involve taking a view on the quantity of need for particular types of infrastructure. And that would somehow involve seeking to determine through each individual DCO hearing and consideration what is required, both as to capacity and as to need, and would have far-reaching implications for all energy infrastructure projects, including renewable energy infrastructure projects, as to whether commercial rivals can turn up at the hearing and say, no, we've got 6 down the road which are better, and you shouldn't be assuming any need for yours. And it would, in my submission, also undermine one of the purposes underlying the DCO system, which one can find summarised in the Divisional Court's judgment in Spurrier, turning to the authorities bundle. And that is at tab 11, and it's paragraphs 22 and 23 on page 183. And it refers to the mischiefs that the Act was intended to address. The 2008 Act were contained in the white paper published in 2007. And then there's a large extract from paragraph 3.1 about some of the problems that afflicted the Heathrow Terminal 5 inquiry as a result of no clear policy framework. And paragraph 23, the judgment, para 3.2 identified a number of particular problems caused by the absence of a clear national policy framework. Inspectors at public inquiries might be required to make assumptions about national policy and need, often without clear guidance and on the basis of incomplete evidence. Decisions by ministers in individual cases might become the means by which government policy would be expressed, rather than such decisions being framed by clear policy objectives beforehand. And it continues about problems for other parties in that context.
How does this work? I'm going to say globally, but that's the wrong word. Nationally. I mean, here you've got a policy which says we need electricity generation, we need fossil fuel electricity generation. We're not going to set any targets about it. So 100 people apply for development consent orders to build fossil fuel plants, and each one of them says, well, don't look at what everybody else is doing, you need me, I'm within the policy, so give me development consent. So 100 development consent orders are made, and if all of them were to be implemented, the market would be, the electricity generating capacity of the country would be completely saturated with fossil fuel generation, and that would, if you like, drive out the need, the consumer need for renewables, because everybody's much more cheaply supplied with fossil fuel. Is that how it's meant?
But the debate is not removed, but it's removed from the MPS and it's put into other vehicles, right. In particular the electricity market reform, the EU ETS, which involves trading of carbon emissions and also competing for contracts. So that immediately puts a commercial cap on how many proposals can actually come forward and be built and provide the requisite amount of electricity under the various considerations.
Right. So your answer then is it's taken care of by a different legal mechanism.
Yes.
Through the electricity reform programme.
Yes, my lord. And that is the burden. I didn't take your lordship to all the passages, but the burden of part 2 when looked at as a whole in my submission.
Thank you.
There was a reference, I think, at 3324 to these other mechanisms.
Yes.
Is that right? Yes.
Yes, 3324.
And they're all explained in earlier passages in section 2, or part 2 rather.
Yes, they are, although the electricity market reform project has reached fruition through legislation in the Energy Act 2013.
Yeah, that's referred to at 2219, I think. Or at least the project is referred to.
Yes.
You've got to remember all of this was being crafted in the early 2010s, wasn't it? This was 2011, I think?
It was published in 2011, but the preceding version was 2010. That was subject to the SEA.
It's a market-based system in which there has been significant intervention in the market by government, or by Parliament, actually.
Yes, and there are other future signals or incentives that it can legislatively provide for. The latest position on the EU ETS is that that has, insofar as relevant, that has been domesticated through the Greenhouse Gas Emissions Trading Scheme Order 2020, which were made on the 11th of November 2020. But clearly there may be other interventions and legislative developments in the context of Part 2 and those overall market responding mechanisms.
Yeah. Have you a copy of that? I don't think it's been relied on before, and I'd like to.
Of course. It's a long read, I'm afraid. But,
perhaps, in a sense, counterposed to your point here is the first part of paragraph 420 of the decision letter, where the Secretary of State is speaking of a number of other schemes having planning consent, but there being no guarantee that these will reach completion. That's the first point that is
yes.
taken there.
It shows it's a response to that, indicating that can't be a measure of need. First of all, that it's an illegitimate approach. That's the response, but because it does mean an attack on the policy. But secondly, as your lordship indicates, yes, there's that is consistent with the market-based approach. That there have, in fact, and the evidence was before the examining authority, there were quite a few projects which had not been commenced, but have been given
the fact that Drax has got its development consent order doesn't mean that it's going to build this power plant, nor does it mean that even if it does, it's going to be able to generate electricity from it.
Certainly the former is correct, yes. The second point would depend on whether they are admitted into the contracts process. But, and so finally on ground 1, just to look at what the Secretary of State actually did in relation to need, briefly, because I appreciate you have been taken to passages and you've read it already. I would make three propositions. First of all, the Secretary of State proceeded on a correct interpretation of policy, namely that need was as demonstrated in the policy. And that is paragraph 4.18 of the decision letter on page 128. Secondly, the Secretary of State had regard to the contribution of the proposal to need, and there I would refer in particular to paragraphs 6.6 and 6.9, That's 6.6. She acknowledged the GHG emissions from the development. That's page 145. Line 7, I think. Acknowledging the GHG emissions, and I'll come to the balance separately. While acknowledging that, the generating capacity of the development, neither 2 or 1 unit configurations, is a significant argument in its favour. The maximum 3.8 gigawatts possible if the applicant builds out both gas-fired and battery storage units as proposed. Battery storage units being dealt with separately. Therefore, the Secretary of State considers the development would contribute to meeting the identified need, and substantial weight should be given to this in the planning balance. And one has that again in paragraph 6.9, lines 3 onwards. Secretary of State's overall conclusion on the planning balance that there are strong arguments in favour of granting consent for the full 2 gas units, 2 battery storage units, 3.8 gigawatts, because of its contribution to meeting the need case. And the third proposition is that the Secretary of State applied substantial weight to the contribution as entitled to do pursuant to the policy, both in the context of section 104.3 and in the balance under 104.7. So in 104.3, it's paragraphs 418 to 420.
Sorry, 418 to
418 to 420.
Yeah.
And in 104.7, it's at 6.6, which I've just referred to, which refers back to paragraph 420. And it's also clear that the Secretary of State at 420, the end of 420, expressly grappled with the arguments before her that the matters that the examining authority had identified should diminish the weight to be attributed, but did not agree with that, having regard to what the policy itself establishes, and was entitled to do that.
I'm so sorry, it's my fault. I missed the proposition itself that preceded those references.
That the Secretary of State did give substantial weight to the contribution to need of the project as entitled to do, both pursuant to 104.3 and 7. And 104.3, it's 418 to 20, and 104.7, it's 6.6, which refers back. And in my submission, finally, on ground 1, it was neither irrational nor perverse of the Secretary of State to reach those conclusions, which are clearly a matter of planning judgment for the Secretary of State.
There's one other, perhaps loose end, perhaps not loose. If you come back to 323, the last sentence, which we've been looking at quite closely. The judgment inherent in that question, which is the proportionality judgment, is there any prescribed technique or scope for that exercise?
Not in the terms of 323, but it first doesn't require a quantitative approach. And of my submission, secondly, a quantitative approach would be, if it was to be adopted or required, would be inconsistent with the overall context of EN1.
I'm not sure I entirely understand that. The project's actual contribution is, at least in part, quantitative, isn't it? You say how much electricity is this
insofar as it has a size, it is, to that extent, capable of being quantitative. But it doesn't, so Your Lordship's right to draw me up on that, but it doesn't require or involve any assessment of the quantitative position on the need side. That, in my submission, would be illegitimate in the context of the EN.
But you don't say, or do you say, the bigger the better?
No, I don't say the bigger the better, because the need is static. The need is simply a need for CCR fossil fuel generating infrastructure. So it's not expanded by the size. It's a policy need. But when looking at the contribution, that does enable consideration as to what the output will be. Doesn't necessarily mean that is, it's certainly not a conclusive factor, and it doesn't dictate that you need to give extra weight necessarily to that. But it is relevant in considering how the adverse impacts are then considered, because if it is a minuscule contribution, some even modest impacts might be not outweighed by that.
A slightly different example. I mean, take nuclear, for instance. I mean, there is quite a debate amongst those who know about these things about whether it's better to have one big reactor or lots of little ones. How would that go into 323?
Well, nuclear energy has got its own national policy statement, EN6, which is subject to EN1, but it's capable of setting out things that are that can vary.
If I've set a hair running, I apologise.
And so that does have a number of provisions about how you approach contribution. There are six MPSs in total.
Just to try and help me understand what the words mean on the facts of a particular case, the anticipated extent of this project's potential contribution is the 3.8 gigawatts if you have all these gas-fired and battery storage units. Is that right? We know what the anticipated extent is at a maximum, don't we?
Yes, we do.
So that's the potential. I wonder then, I'm still worried about the word actual, what that's trying to get at actually. Because looking at the sentence again, I know what you said about it this morning. The weight which is attributed to considerations of need in any given case, that must mean whether or not you give it substantial weight, which is what the policy says, should be proportionate to the anticipated extent of a project's actual contribution. I'm trying to see what the person who wrote this was trying to weigh. On the one hand, I've read the early bits and it's substantial weight because it meets need. Then it's looking at something else, which is the anticipated extent, which is future, of a project's actual contribution. So I'm back to, is it really talking about, is it likely to happen? Or even though you've got planning permission for 8 enormous things on one site, the reality is you're only going to build 4. And how does that matter? Because it's still substantial need, whether it's 4, 6 or 8.
Yes. Well, in my submission, I'm not sure actual really adds much to it, but it would have an application to the matter before the Secretary of State in this case, but it would have a relevance in circumstances of where the need was described as urgent. And so where you have an urgent need on one side, as in the case of a number of other,
which do have the urgency,
then the actual contribution will be relevant because the timing when that may come forward will be relevant to the extent to which it satisfies the urgency of that need. We need it.
So if we're not dealing with...
It's going to come 15 years later.
Yes. If we're not dealing with one of those types of fuel generation that's urgent, if it's the ordinary fossil fuel one, the sentence then you seem to be saying is meaningless because the weight to be attributed to it is substantial. It's got to be proportionate to the anticipated extent of the project's capacity.
I mean, in my submission,
the
words are really emphatic there. The contribution, the actual contribution, rather than limiting in their or definitive in their extent. It's in this context, it's simply emphatic that we have regard to the actual contribution. So, but I think it would be, my submission would be inconsistent with what the rest of the policy is saying, particularly in Part 2, about not seeking to constrain the number of consents that come forward by reference to any quantitative measure, to be requiring some forecasting of how the capacity market system will actually award contracts, and similar complexities, which, however expert the panel may be, are not really within their scope, in my submission.
It could either be meaningless, or it may just be, just in case I haven't thought of something and it turns out in a way I can't anticipate to be disproportionate. Have a look at that as well. Just trying to give it some meaning.
The Secretary of State, in paragraph 419, poses a question which is open-ended. Does she? Second sentence. Secretary of State has therefore considered whether, in the light of the examining authority's findings, there is any reason why she should not attribute substantial weight to the development's contribution, etc. All of this, of course, clearly framed by her reference to 323. So she's considering this development and its contribution to meet the identified need for that particular form of infrastructure, as she refers to it. And then she goes on to deal with the considerations that she regards as relevant to that question. She doesn't pose the question in terms of whether she can go above substantial weight.
No.
Indeed, she turns it the other way round. Should she go below substantial weight? So she seems, does she, to be applying it as a kind of check, almost.
Yes, well, I think that's consistent with what's said in 420.
Yeah.
Her conclusion is that it shouldn't diminish the weight. So it's not going beyond substantial weight, but it is saying that when applying that test, the weight shouldn't be diminished in the context of considerations set out earlier.
And you submit to us that when you made the last of your, in fact, 4 propositions,
Yes.
419 and 420 manifest a reasonable application of the policy.
Yes, you're quite right. There were, I think, 4 propositions in the end, because the 4th one was that she did consider whether to
or a not unreasonable,
apply.
A not unreasonable application.
Yes.
Not a new separate test, departing from all the other policy things. It's the weight is substantial, but bear in mind, you've got the need, which is substantial. Consider the anticipated extent of what's proposed, and just check that it's proportionate.
Yes, madam.
It's a kind of safety valve measure in some way.
Yes, it is, madam.
Right, so that's ground 1.
That's ground 1. Ground 2. And as it's pleaded in or put in the skeleton at 34, it is whether EN1 522 and the equivalent passage in EN2, which is the specific MPS dealing with fossil fuel generating infrastructure, but defers to EN1. And as pleaded, or argued, it's whether 522 is a statement of generality or applies to individual proposals. And as argued in my submission, it can be dealt with briefly. And so turning to 522, which is supplementary bundle tab 2, page 78. The argument is that the passage from line 6 that government has determined CO emissions are not reasons to prohibit the consenting of projects which use these technologies, has only general force rather than being applicable to individual projects. In my submission, that simply is at odds with the ordinary meaning of the language, which is specific to the consenting of projects. So that's the way in which it is primarily put at the appellant's skeleton argument at paragraph 34. I'll come on to how it's applied under ground 3, because I think it belongs there. The policy does not say that CO2 emissions are irrelevant in the process, and it obviously doesn't say that EIA shouldn't be carried out. It expressly says that it should, but it adverts to the policies set out in section 2, including the EU ETS, which apply to those emissions, in other words, the other mechanisms. And before turning to what Secretary of State actually did, there is an additional point that has emerged in the skeleton that Para 522 is somehow inconsistent with Regulation 21 of the EIA regulations. And I'd make 3 short points in respect of that. First, that the EIA process does not prescribe or limit the outcome. Secondly, this is a policy which has been subject to parliamentary approval, and the time for challenge of the policy is obviously long past. Third, that these passages are setting a policy framework as they are entitled to do, having been subject to strategic environmental assessment. And I don't think I need to turn to the Thames Blue-Green judgment of Mr. Justice Ouseley, or even the judgment of Lord Justice Sales, for the modest proposition that the EIA regulations do not preclude a decision which is made in the light of the strategic decisions which have been subject to SEA. There's no suggestion of constraining the assessment at all, as made clear in the policy. But one is entitled, the decision maker, to have regard to the policy that is contained in 522 when considering the GHG emissions question. And that then brings me on to what Secretary of State actually did, because she did not treat GHG, greenhouse gas emissions, as irrelevant, but decided to ascribe no greater weight to them than contained in 522, but was open to giving greater weight to those emissions in the context of this case and the balance that she needed to and did strike. So if I can take the Lordship briefly to the decision letter, CB2, Tower 6. At 416, she expressly acknowledged the significant adverse impact of the proposed development on the amount of greenhouse gases that will be emitted to the atmosphere, but noted the policy set out in the relevant MPS makes clear this is not a matter that should displace presumption in favour of granting consent. But went on at 417 to note, I won't read it all out, but does say, notes the need to consider these impacts, line 3, within the overall planning balance. To consider whether the exception test set out in section 104.7 applies. The XA considers the development will have significant adverse impacts, which the Secretary of State accepts may weigh against it in the balance. And indeed, significant adverse impacts are given in the policy in 522, but doesn't consider that the panel was correct to find that these impacts should carry determinative weight in the overall planning balance once the benefits are properly considered, including its contribution towards meeting need, weighing the different factors, taking account of GHG emissions. And moving on to 6.6, which is the balancing exercise. Halfway down, line 7, while acknowledging the GHG emissions from the development, the generating capacity is a significant argument. I've read that passage earlier. But also 6.7 goes on to consider this matter, particularly in the context of the net zero requirement in section 1 of the Climate Change Act. But that policy doesn't preclude the development operation of gas-fired generating stations in the intervening period. Therefore, while the policy says GHG emissions from fossil fuel generating stations are accepted to be an adverse impact, MPS also says Secretary of State does not need to assess them against emission reductions, nor does the MPS state GHG emissions are a reason to withhold the grant of consent. Open to the Secretary of State to depart from that and give greater weight to GHG emissions, but no compelling reason to do so in this instance. Now, I know my learned friend Mr. Jones has referred to the compelling reason, but in my submission, the way in which the judge dealt with that matter in Paul Bundle 1 in his judgment at paragraph 180 on page 165, Mr. Justice Holgate's judgment, CB1 165, para 180.
Yeah.
That was an argument that was run by Mr. Jones in the court below, saying that, well, that's a threshold test. And the judge in my submission correctly calls that an overly legalistic approach. Secretary of State was simply expressing a matter of planning judgment, no sufficiently cogent reason for giving more weight to this matter and entitled to exercise her judgment in that way. In my submission, that is a fair way, a fair characterisation of the approach that the Secretary of State took. And of course, in addition, going back to the decision letter, I'm sorry to dance around, but this is the last reference under this ground. 5.9, in fact, it's 5.6, 5.9, so on pages 139 to 140. There is, of course, a large section, a whole section on the Climate Change Act and the net zero target and the change that had occurred in 2019 through the legislation. And 5.7, the Secretary of State accepts that is a matter which is both important and relevant. And just pausing there for a moment, so important and relevant is a matter that is required to be taken into account. It's a matter is important and relevant.
Yes, Mr. Jones showed us the,
yes.
the section.
And that
106,
might be seen as another way of what the Planning Act 2008's way of talking about a material consideration rather than got its own language there, as your Lordship pointed out. And so there is analysis here, 5.7 to 5.9, in particular at 5.9, as to whether whether the policy should be approached in a different way. And this was by reason of the net zero change. And this was the subject of ground 8 before the High Court, which is not pursued here.
We didn't get permission from His Lordship, so that's why I haven't addressed you on it.
No. But it is relevant, clearly, to all the matters that the Secretary of State was taking into account in undertaking a balance. So that's all I was going to say by way of ground 2.
It is just slightly odd, though, isn't it, that it seems that the policy says, well, you can't refuse a development consent order on the grounds of greenhouse gas emissions alone. But if you can find anything else, then you can add in the greenhouse gas emissions.
That might be that's certainly the reading that the judge applied to it, and that might well be the case. It doesn't arise.
Seems a slightly odd reading, doesn't it? That you've got a very minor heritage effect, or very minor, I don't know, traffic generation or something, and greenhouse gas, and you know, the other, whatever the other matter is, it wouldn't justify refusing consent on its own, but chuck in the greenhouse gas effect and you can. It just seems a bit odd.
Well, another reading might be the simpler reason that it's not a reason in itself or combined with other factors.
Well, I can see that could be the policy. The policy could say,
yes,
forget greenhouse gases.
Yes.
You know,
Which
we've dealt with that at the
yes.
strategic level. Forget them. But that's not what the judge said.
No. But it's not necessary to reach a view on that question to conclude that the Secretary of State was correct in this case.
But the point my Lord raises could perhaps be overcome in this way. Paragraph 522 is stating, as we said earlier, or as was said earlier, that it's not to be regarded as a knockout blow. But in every case, you have to take it into account as appropriate in the balance of considerations. It may actually be the only negative factor. You're not precluded from seeing it as the decisive factor in a particular evaluation of the project. Once you've done the weighing exercise.
Yes. Well,
But your submission anyway is that in this instance it's manifest that the Secretary of State undertook a weighing exercise.
yes, my Lord, that's shying away from an answer to your question. I think that's how I would ultimately respond.
But whether you answer my Lord's question or mine, you don't get to the answer the judge got to.
That's certainly one implication.
And that's you know, I just wonder whether we need to say something about that, because the position the judge got to strikes me as being really rather odd. It may not matter for the outcome of the appeal for precisely the reasons you've just given, but if the law is going to be left in that state,
Yes.
we might need to think about what the answer is.
Yes. Well, my Lord, I'm not defending my case on that basis necessarily.
My Lord, the
that's
only
what I would say.
point I would make is I don't, and the learned friend will have to take a decision. This case has been defended on the basis not that it should be upheld for different reasons,
Well, that's
those
true.
given by the judge, and neither my learned friend or the opponent filed as they would have been obliged to do so. So we've fought the case. That is why our skeleton argument focuses on the judge's decision. I just make that.
When it comes to a matter of policy interpretation, we must do our best to find the right interpretation of the policy. Our hands are not tied by submissions made by either side, of course. So, in that sense, you know, we have to look at the thing afresh, in any case. But ultimately, of course, we have to decide whether the Secretary of State made an error, a legal error.
Yes, my lord.
We're not constrained by pleadings
No.
in doing that, I don't think.
My submissions do not depend on that, nor does the chain of reasoning.
Indeed, paragraph 180 doesn't depend on that, does it? Other parts of the judgment do, but does 180 of the judgment depend on that? No, it's other paragraphs.
No, I think
179.
180.
180, I don't.
No,
No, that just goes to this
the compelling.
the threshold argument, which is a matter of expression rather than.
167 looks all right, then, does it?
.179 is the key that went on to consider whether the factor should be given greater weight. MPS didn't preclude that possibility.
As long as it's not treated as a freestanding reason. I just wonder whether we've been a little harsh to the judgment below, whether we've made this interpreted in a way that gives rise to absurdity.
I mean, I think we just need to pay attention to the words of the policy. I mean, put in terms of prohibiting the consenting of projects. As if it's a kind of bar, generally.
Well, I think it yes, generally and specific, generally as applied to specific projects. Yes, madam.
Yes, but as it were, an automatic knockout blow.
Yes.
Oh, you're going to generate carbon dioxide, so you must not have consent. That plainly would be a wrong approach, legally wrong.
And the decision letter does not embark on this question, which in this instance is my submission is a theoretical testing of the proposition, but it isn't relevant to the decision that the Secretary of State actually took, because
It may be that in 179 one is being a little harsh to the judge if one says that not to be treated as a freestanding reason for refusal necessarily means other than not to be taken as an automatic knockout blow. But he doesn't put it like that, to be frank. He puts it in terms of a reason for refusal, which is very much a project-specific concept. But as I see it, we have to look at the policy, divine what it means, see whether it was understood by the decision maker and whether she lawfully applied it in the completely conventional way.
yes, ma'am. So that brings me finally to ground 3, which was that in the section 104, which is in the section 104.7 balancing context, that the Secretary of State unlawfully fettered her decision by reference to section 104, by reference to the policy in the MPS. Indeed, in response to your Lordship this morning, my Lord Justice Lewison, Mr. Jones said that the 104.7 process should be unencumbered by the NPS, which goes beyond, I think, the way in which it was put in the skeleton. And in my submission, it's which either way one puts it, it's a mischaracterization of what actually occurred and what is allowed to occur, because the Secretary of State is entitled, in my submission, to apply the policy in the MPS when striking the balance. And that policy includes the weight to be given to need, without repeating the various passages. But Secretary of State's entitled to have regard to that. And there was no basis upon which it can be sensibly argued in my submission that the Secretary of State can be regarded as having her hands tied by policy, because she, as we've seen in the passages earlier, expressly took account of the prospect of not applying the policy. And I won't repeat the passages. And clearly, obviously, took account of the Climate Change Act 2008 change in the conclusion at paragraph 5.9. So in my submission, the argument that it should be the process in 1047 should take place without regard to the MPS can't be sustained. But in any event, the Secretary of State did not regard herself as bound by that policy. This can be seen in the passages I took your lordships to.
Yeah.
That's all I was going to say in relation to ground 3, or otherwise, unless I can assist your lordships further.
Thank you very much, Mr. Tate. Mr. Strawn.
Thank you very much, my lord. So I've got the luxury of going after Mr. adopting everything he says. The slightly less enviable task of not repeating anything he says, which I should do my best to avoid saying anything he's already said. I greatly adopt his submissions and just make 1 or 2 additional points, if I may, as briefly as I can. The first relates to ground 1, but more particularly the question of need. And my learned friend Mr. Tate's already drawn your lordship's attention to some of the other paragraphs of EN1. Could I just invite your lordships back to EN1, one at a time, and draw your attention to aspects of the nature of the need in question. Because what becomes evident without laboriously going through the document as a whole is that it's a multifaceted need. And what I mean by that is that there are a number of elements, different elements, that make up the reason why the need exists. Can I just give you some quick examples? If your lordships would go to 2.2.30 in section 2, I've got the wrong reference there.
No, I don't have a 2.2.30.
No, I just realised that. Sorry, my lords. I'm in section 3. I apologise.
3.2.30?
No, it's 3.3.3.
3.3.3. Yeah. Safety margin. Is that it?
3.3.3, yes. And you'll see there, under the heading of the need for new nationally significant electricity infrastructure projects, under 3.3, there is a subheading, meeting energy security and carbon reduction objectives. And 3.3.3, having explained that in 3.3.2, identifies the larger the difference between available capacity and demand, i.e. the larger the safety margin, the more resilient the system will be in dealing with unexpected events, and consequently the lower the risk of a supply interruption. It is, in that sense, the greater you have the ability to draw upon, the greater your safety margin is, which is part of what's considered necessary in policy terms. Another example, 3.3.4, it's emphasised that that's achieved by a diverse mix of all types of power generation. And then if one turns to 3.3.11, under the heading, the need for more electricity capacity to support an increased supply from renewables, you will see at 3.3.11 that one feature of reliance, greater reliance upon renewables, is a necessary reliance upon other sources of supply to deal with the intermittent nature of renewables. And that's not simply a transitional backup, as that paragraph makes clear. That is likely to be a permanent position. And the court will obviously be very familiar with that basic concept. In circumstances of low wind or low sun, there's a need to still the need for energy. So this isn't just a transitional position. This is a need for all types of energy, where there's an interrelationship between them. And of course, one aspect of that is that the greater the success there is in bringing forward renewable energy, the corresponding greater need there will be to make sure there's the ability to deal with the intermittent nature of that energy, as 3.3.11 is identifying. And 3.3.14, your Lordship referred to the question of trying to reduce demand. But there's another aspect of energy policy being expressed here. That one of the features or the ambitions of moving to a low carbon economy or energy supply, for example, electric cars, they do need to be charged. And what is being identified is that depending upon the success of that shift to electricity, reliance on electricity in those sectors, the overall need or energy demand may be double or triple, depending on how successful it is. All of those points expose something which is very clear in my submission from reading these parts as a whole, that the whole concept of a quantitative target or limit is actually contrary to the objectives of the policy. It's also impossible to quantify. And my Lord asked a question about footnote 16 at the beginning of chapter, or part 3, which talks about in determining planning policy, the government considers a range of projections and models. In my submission, that footnote is picking up a summary of what comes in part 3, explaining in detail how difficult it is to predict what the needs will be, and indeed, in some respects, how the need will actually increase the more successful you are in moving to this.
I wasn't drawing attention to that footnote for that particular reason. It was really the last sentence of the footnote, in effect saying that it's all going to fluctuate. So it was exploring the proposition that, as it has been put, need is static, whereas this footnote suggests that it isn't. It's dynamic.
My Lord, the policy need is static.
Right.
The need will remain and is fixed by this policy until such time as the Secretary of State determines otherwise. So that is static. That is a constant. The degree of the quantifiable aspects of the need are the things which are impossible to quantify, and they will fluctuate, and indeed fluctuate against my own friend in favour of other forms of energy, the more successful you are.
I understand. I understand the point.
So that is why, in my submission, if you take all those points together, when one comes back to the crucial question of paragraph 3.2.3, what is it actually requiring the Secretary of State to do? The one thing it is not requiring the Secretary of State to do is embark upon an exercise, I submit, a futile exercise, of trying to quantify the overall need for the different energy projects.
Yeah.
It was a futile exercise that the examining authority embarked upon, which involved, as it's not necessary to go to the report, but making all sorts of speculative assessments of permission and consent. But none of that would answer even the bigger question of how much you're going to need anyway in light of these imponderables. And so, focusing, if I may, just for the purposes of ground 1, on paragraph 3.2.3. I don't want to add to the debate as to the precise meaning of the words, but can I just, and I'm quite content with the description of safety valve that's present in the words that appear after giving substantial weight to the need. Then one looks at questions of proportionality. But can I just make this point? This paragraph 3.2.3 is expressed in terms of need for all the different projects that appear in this policy statement. And your lordships will see from the index, which is on page 11, that it includes not just renewables. This is part 3, the index. Renewables, nuclear, fossil fuels, but also these: electricity network infrastructure, nationally significant gas infrastructure, and new nationally significant oil infrastructure. There are corresponding sections in part 3 which deal with each of those different types of energy projects, loosely called, where there are nuances, different nuances, as to how one would assess actual contribution, the words my Lord Justice Lewis has raised. And can I just give you an example of that? If you look at electricity network infrastructure, which is dealt with in 3.7, you'll see that it's a glorified term for, in effect, the wires that connect up the
turbines with the substations. Yeah.
Indeed, but this is the network infrastructure, the national grid type conductors or pylons, for example. But you can see that where those sorts of projects are concerned, if you look at, just as an example, 3.7.10, there is an urgent need for new electricity transmission and distribution infrastructure identified in the first sentence, and particular types of lines. But the IPC, in this case, the examining authority, has to actually embark upon a rather different exercise of need assessment in that context, because you'll see that in order to be satisfied a need exists, they do need to look at the generating station, where the links are occurring, and the extent to which those are considered to be meeting supply current or anticipated future levels of demand. And that just, I don't want to take the court down into an assessment of what is required under that, but all I'm pointing out is that when you come back to 3.2.3, it's important to recognise that it's actually catering for the test that applies to a whole load of different infrastructure projects. And therefore, it's entirely right that the Secretary of State should have in the policy here a recognition that you may need to look at a project's actual contribution, which, for example, in the case of a pylon, is it actually connecting up something which is required in a particular location, for example. It doesn't have as much resonance in my submission, of course, for a project like this, but it doesn't need to, because it's a paragraph that's applicable across the board for all of these projects. And in my submission, my learned apprentice hunting for a meaning which assumes that this is a policy statement that's only applicable to generating stations, which it isn't.
I was wrong to say it's meaningless. It's got some real meaning in some context, but in this context, it's, if anything, a safety valve or...
Or it doesn't even need to have a meaning in this particular context. If the need doesn't arise, but it certainly does have meaning in
another context.
So well, that's really what I wanted to just add to in relation to ground 1 and paragraph 3.2.3. But I certainly do adopt what in my submission is crucial in this case, which is to focus on the Secretary of State's position, because that takes us away from the abstract to the concrete. And in this case, in my submission, for the reasons my own friends already said, I won't go through again, paragraphs 4.19 and 4.20 are an impeccable application of that paragraph 3.2.3 to the specific project in question. And in paragraph 4.20, in my submission, generously, the Secretary of State did actually engage with the argument about permissions and consents that the examining authority had raised, albeit strictly speaking, you may not have needed to do so, but those were arguments before her, and she explained why they're not going to help in that assessment. Could I then just turn to ground 2, just to add something brief about that, I hope brief, and that is the question, two points I just want to make. The first is about the difference between material consideration and the weight a material consideration should have, which will be well known to the court, but in my submission, my learned friend is still confusing the two. And the second point is just about the words in paragraph 5.2.2 itself. On the first point, I apologise for stating the obvious in our skeleton argument, but there is a fundamental distinction, both in town and country plan generally, but also in this context, between a material consideration or relevant consideration and the question of what weight, if any, it should carry. And obviously Lord Hoffman's exposition of that principle in Tesco stores is well known. But the passage which is less often cited is the passage at the end of Lord Hoffman's speech, in which a submission was made that if a material consideration is a material consideration, it must carry some weight. But of course, Lord Hoffman made the point, in my submission, must apply equally in this context, that the question of what weight, if any, is entirely a matter for the decision maker, and it's perfectly legitimate in law to have regard to something but decide to attach no weight to it. And one should not conflate the two things. But that's precisely what my learned friend's doing in relation to paragraph 5.2.2 of the policy statement. That is a policy statement which makes policy, Secretary of State policy, on greenhouse gas emissions in the context of these sorts of generating stations. They are not reasons to prohibit these generating stations from going ahead. And that is a matter of policy. That does not mean that they are ignored. They're not treated as immaterial considerations, greenhouse gas emissions. Nothing in the policy says that they are, nor has anything we have submitted in this court or below a submission to that effect. But it's perfectly legitimate for the policy statement to say, as a matter of policy, greenhouse gas emissions, whilst they are a significant adverse impact of certain types of projects, are not going to be reasons for prohibiting these needed stations from going forward. Why? Well, that's explained in section part 2. Greenhouse gas emissions will be controlled through a mosaic of other mechanisms. Both the EU ETS, we've heard about the electricity market reform, and the ability for the Secretary of State to control emissions in a different way, other than through the planning forum. And your Lordship's already heard submissions about the ability to, in effect, the planning system can grant consent. So there's another mechanism to control it. There is nothing at all wrong in my submission by having such a policy. Indeed, that's a matter for the Secretary of State and the day. Why does that matter? Well, it matters because my learned friends now try to equate some error in the Secretary of State's decision with the environmental impact assessment regulation. And that is, in my submission, exactly the error of treating something as a difference between a material consideration and the weight to apply. The environmental impact assessment regulations applicable in this context are procedural, otherwise being described as adjectival. They set a process to follow by which certain information has to be considered. The one thing they do not do, and do not purport to do, is dictate an outcome. They certainly don't dictate the weight to be applied to adverse impacts in environmental terms. They just require you to assess them. And in this case, that is why paragraph 5.2.2 recognises that an environmental statement will identify greenhouse gas emissions, and should do because of that obligation. But the policy can then legitimately say they will not be a reason for refusing consent for these projects for the reason I've explained. My learned friend, in his skeleton argument, on a repeated occasions, has said that's a breach of European law, that outcome. It plainly is not. European law does not require the Secretary of State to set any weight on any particular consideration, as long as you take them into account. Did the Secretary of State comply with Regulation 22 in this decision? Yes, of course. Greenhouse gas emissions are identified. The reasons for why she has done what she's done are explained, and they're integrated into the decision because you can read them in the decision letter itself, and that's all the law requires, and unless you're going to convert it into a substantive requirement, which it is not.
Yep.
So, my lords, for those reasons, we say my learned friends made the error which one shouldn't make. I just wanted to finish on ground 2 with just focusing on the words of 5.2 itself, because my questions arisen about what the judge may have said about them becoming freestanding reasons for refusal. There has been reference to what we said below. We didn't make the submission that you could combine them with other things to become reasons for refusal. We don't accept that's the right analysis. Whether or not the judge is saying that, I'll leave for others to consider. But the policy is, in my submission, very straightforward. It's deliberately identifying these as significant adverse impacts, but which are not going to be treated as reasons for refusing consent. And it's important to see it's not just that that's stated in paragraph 5.2.2, page 78 of the supplementary.
So are you, sorry to interrupt you, are you saying that 5.2.2 means that CO2 emissions are not reasons to prohibit the consenting of projects, no matter how extensive those emissions are?
My lord, yes.
Yeah.
And can I just, it's not simply saying that. If I could just take your lordship to the words, they're not reasons to prohibit the consenting of projects which use these technologies, or to impose more restrictions on them in the planning policy framework than are set out in the energy NPSs. And then we're told what those are, e.g. the CCR. Your lordship will know this is a proposal which is CCR, carbon capture ready, had to be, and that's built into the DCO requirement. And that means that land has to be kept available so that once the technology is available for viable carbon capture storage, there's the ability to convert the generating station into a carbon capture storage generating station. The policy is saying that is all that is required to be imposed for these projects.
That does seem to run counter even to procedural obligation. A relevant consideration is something you ought to think about. Okay, having thought about it, you may say it's of no weight here, but it expects you at least to consider whether or not it should be given weight and what weight. But if you're saying, yes, you must include it in your environmental statement, you can say what you like about it in the environmental statement. It will make no difference. The decision on that has been taken. It is a pointless exercise, but please do go through it. That's not consistent, is it?
Well, my lord, there are two answers to that. First of all, it is consistent because the reasons why that policy has been arrived at are explained in the NPS. It's not a policy which, for example, says we will allow greenhouse gas emissions to occur, come what may.
Because
it's very much the opposite. Yes. They are going to be controlled, but it's just not through the planning system. They're going to be controlled through the Part 2 mechanisms. And it's perfect. If one thinks of EIA regulations about development consent, there's plenty of law that requires one to look at the development consent process as a whole. And if you have other mechanisms to control something by way of, as in Part 2, then it's perfectly legitimate to control those mechanisms. So I accept my lordship's point. If you were saying you can tell me whatever you like about them, but I'm not going to worry about them, then I might be in more difficult territory. But that's not what the policy says. The policy is actually a carefully crafted policy of allowing things to go ahead, but controlling greenhouse gas emissions through another process. and they are recorded in the ES. And so in my submission, it's more than saying they're not reasons to prohibit consent. It's saying you shouldn't impose more restrictions than are specified through the policy framework itself.
We've been focusing very sharply on the middle part of that paragraph, Mr. Strawn.
Yes.
Perhaps not focusing always on the first sentence, which makes the obvious enough point, but perhaps important as a contextual point here. CO2 emissions cannot be totally avoided, subject, of course, to these new technologies. If you have a fossil fuel generating station, electricity generating station, then in its conventional format, it will necessarily be generating what we call greenhouse gas emissions.
Yes.
That's just what it does. It would be at the crudest level, you could say, there would thus be a denial within the policy of itself. If you, as it were, in one breath say, well, we can have fossil fuel generating capacity, but we can't have it because it's fossil fuel generating capacity brackets which generates greenhouse gas emissions. I mean, that's the context. I put it very crudely. I appreciate that. That is the context, though, isn't it, in which the statement is made in the middle of 522.
It is the context, my lord. It's also the other part of that context is, of course, what's said earlier on in the policy. Yeah. In fact, the way it's described in my submission is that CO2 emissions are an inevitable consequence of certain types of generation of power. They can become part of the low carbon economy with carbon capture storage, albeit they still generate some, but they're expected in due course to become part of low carbon energy provision. Yeah. But, my lord, what's said in section 2, and is also borne out by reality, is that there is a complete ability to control any greenhouse gas emissions, because ultimately you can turn off, by regulation, you can turn off the ability to generate any power from these stations. And you'll see that there's discussion about coal, for example, where the various regulations that are introduced have required the emissions to come down to such a level that actually certain projects are phased out. So, that is, in my submission, the context here is a policy which is saying that planning is not going to do all the work. And the great danger is perhaps seeing the planning context, this planning act, this DCO process, as being the answer to all of these questions, whereas the policy is saying precisely the opposite. We want to bring on these projects. We have a need for them. We will control carbon CO2 emissions through another mechanism.
Yeah. No, I think we've understood that.
I'm sorry, but so I don't think I need to say anything further on ground 3 rather than to drop my own submissions unless I can assist you further. I'm just conscious I think I said I was going to give your lordship 2 answers.
You gave us one, but one will be enough, I'm sure, unless you have another.
Well, one is the second answer is section 104, section 7, which of course is in principle, and if you want to call it a safety valve, but it is, at least in statutory terms, does give the ability to do precisely what the Secretary of State did do in this case, which is to say, should I go outside the policy? So, well, unless I can assist.
No, thank you, Mr. Strawn. Any reply, Mr. Jones?
My lord, yes. Can I deal first of all with the submissions of learned friend Mr. Tate and also Mr. Strawn on the role of the MPS and planning system. I'm accused, or the claimant is accused of claiming that this planning policy should control climate change, and that this is the sole mechanism. But section 2, and without going through it, and neither my learned friends did go through it, but I know your lordships will have read it, does not provide the answer either Mr. Tate or my learned friend said, which was a mechanism to control development and to control carbon and provide a complete set of controls over greenhouse gas emitting development. It's not there, and you've not been taken to the passages in any legislation. My learned friend just waived a bit of the transition of the ETS. The ETS does not provide that degree of control, and I haven't looked in detail at what's proposed for 31st of December. It's not going to go beyond that, and it's only going to apply. So I just refer to 2.2.10 and 2.2.11 that make clear, this is in the MPS, that this is part of a package of transition to the low carbon economy, and this planning framework is intended to do that. My learned friend picked a few passages. I won't take your lordship to it, but 2.2.4 refers to the planning framework, setting the framework for control of carbon, of energy infrastructure. 2.2.19 talks about, which my learned friend Mr. Tate referred to, is this MPS influencing the outcome. And 3.21 as well spoke about the planning framework. So whilst I accept we've never said that there aren't other measures, other legislation that deals with across the board, it is wrong in our submission to submit that Section 2, which is headed which has within it the transition to a low carbon economy, is saying this planning policy is not about controlling or helping that transition by looking at various different types of development. So, and the energy contract system does not overcome the problem that my Lord Justice Lewison put to my friend Mr. Tate. He just asserted that there's some control mechanism. That's been no part and no evidence before the Secretary of State. It's not set out at all in the policy. How could it? It didn't exist at the time. And the court is now being asked on faith and assertion by my learned friends that there is this magical system to which they haven't referred that deals with it all. The Section 2 does not say that either. It doesn't say that you cannot deal with it. Now, there's a difference between my learned friends on the issue of greenhouse gas on ground 2, but just on ground 1, my learned friend Mr. Strawn said in respect of 323, this passage we spent some time looking at, the weight to be attracted, considerable need, etc., proportionality, actual contribution, applied to all the energy types. That's correct. He took your lordship to one section which hasn't really featured in any of the arguments before, but to do with network. Page 44, the need for a new electricity network infrastructure, which you'll see at 375 has the express target actually of 15% UK's energy to be produced with renewable resources, and has other matters such as 3710. And then he took out of that one example to say that therefore defines the meaning of the general proposition at 323. So one particular example of a network which doesn't apply, point he made, doesn't apply to any of the other infrastructure categories, and you can look through them, and certainly not the one that's the subject of this appeal, and then says you've got to give what we submit is a convoluted interpretation of what it means. We don't accept Mr. Tate's submission, where we say he struggled to explain what proportionate was. I agree with Mr. Strawn, 3.2.3 is dealing with need. It's not dealing with adverse consequences. Mr. Tate's submission, which he says is the right approach to take, is that proportionate involves a weighing up of the balancing exercise at 3.2.3. Nothing of the kind. It's to do with what it says on the tin, an examination of the contribution to need. So the duty in interpreting this policy, we
Wait a minute.
Yeah, yeah.
In your example about flying back to Edinburgh to get your papers,
Yes.
you were looking at the adverse consequences, namely the cost of the airfare, as one part of your proportionality exercise.
Yes, yes. The thing with analogies, I was using that on the point of, are we looking at a quantitative thing? Do you need to have two quantitative points? And I mean, the arguments seem to be shifting around in response, even between my two learned friends when we come to ground two, with different points being run. But here also, I was answering them, my lord, the point about are we actually, in order to have proportionality, do we need to be, in terms of looking at proportionality in the context of need for the development, that we actually look at a quantitative point, and that's the example I was giving. You need, in our submission, it's meaningless unless you have some quantitative assessment of what that need is at the time for you to then see what the actual contribution to that need will be. So my learned friend Mr. Tate says, oh, proportionality, we're actually in a balancing exercise with adverse effects. And my learned friend Mr. Strawn says, oh, it doesn't really apply. There are all these other categories. We haven't looked at them, but look at electricity networks and they've got different things. No, you take the general statement and you don't apply it by one example and work it back. If it were meant what Mr. Strawn meant, it would be cut out of 3.23 and it would just appear in respect of the network system if it had the meaning that. So in our submission, therefore, that the position remains the same. Remember also the passage of an MPS and the decision maker are maybe two different things. We assume that the Secretary of State he has control, or she has control on whether to initiate a review, but has no control over whether or not a new MPS will get through. And that is why it is perfectly right that, first of all, one should be able to look at the contribution. And what is said against us on 3.23, oh, it's impossible to do. On the one hand, Mr. Tate says, and Mr. Jones, oh, it's all impossible to make, it's a futile exercise. On the other hand, they say, don't worry, it's all been done under Electricity Contract Act, ETS, it's all being done under that process. Well, either it's something that you can't do, or it is something you can do. Can't have it both ways in our submission. And this policy is supposed to be an integral part. I mean, your lordships will see all the references throughout the whole policy, and we can all cherry pick, but of the passage towards a low carbon economy by a set date. And in answer to Mr. Strawn, it's not right to say, as he says, the need for backup fossil fuel is something that will remain the whole time. So I just take your lordship to page 44, 368. The need for fossil fuel generation, which Mr. Tate opened, I think, his reply with, his response. He said, we see this capacity may be replaced by new nuclear renewable generating capacity in due course. So it talks about the closure of the fossil fuel generating thing. It says in due course. It's clear that there must be some, emphasis, some fossil fuel generating capacity to provide backup, backup means obvious what it is, for when generation from intermittent renewable capacity is low, and to help with the transition to low carbon generation. It's important, it should be low carbon, etc., etc. So what we're looking for is through a transitional period, and the notion that was asserted by Mr. Strawn, that the more renewables and nuclear you have, the more needs you have, bizarrely, under his argument, for fossil fuel because they're intermittent, because the wind doesn't always go the sun doesn't always shine and the wind doesn't. That is sort of a misstatement of fact, but
It
because
wouldn't apply to nuclear.
it wouldn't apply to nuclear. It doesn't apply. There's a thing called batteries as well, and battery storage, and so as renewables become better, and they become more of them and more nuclear, the need for dealing with system inertia and backup declines, and that's recognised in 368. It recognises it's a need for some, and it's a backup, and it's during the transition, Mr. Strawn's assertions are factually wrong and contrary to what the policy is expecting. So against that background, if one looks also, then if I can just deal with ground 2, and then I just want to make some points on the decision letter. Obviously, without having idea how the court put the position below, but can I just take on the issue of greenhouse gas emissions, and particularly in the light of the way that Mr. Strawn puts the case, which is the irredentist position. Can I just take your lordships to tab 13.182, which is Mr. Justice Holgate's written reasons for refusing permission.
So which is this core bundle?
This is, my lord, core bundle 1,
Yeah.
page 182. And your lordships have the judgment, but in my submission it's clear beyond doubt what he meant, and I don't have to rely on the way in which he put the matters to me in the court below, and the judgment. But if one goes to refusal of permission, grounds 3 and 4, the submission that greenhouse gas emissions cannot be a material consideration in section 1047 balance unless the claimant's interpretation of 522 EN1 is correct and the court's interpretation is incorrect, is misconceived. It is possible for a factor to be taken into account in that balance and given negative weight, at the same time respecting the policy principle that greenhouse gas emissions should not be treated as a reason for refusal in their own right. It's not arguable there's an internal consistency in this part of the judgment. We say the reason for refusing permission is consistent with what the judge said in his judgment. Could I take your lordships then just back to the decision letter, because and what the Secretary of State did in respect of each of the three rounds. Sorry, just. Sorry, I put it over there. Sorry, I put it behind. Well, can I just take your lordship to the what actually the Secretary of State did in our submission in dealing with the matters. So, for example, when one comes to first of all 128, my lord, the question is posed 419, and the answer is given, as we say, in the generality at 420, and I don't repeat what's said there. That either, this is, we've got a situation. Mr. Tate is saying 420. The Secretary of State was on a frolic of her own, answering questions that she need not answer, or for the reasons we submitted in opening, she's got it wrong. I mean, 420 doesn't make any sense if 419 just means you don't look at the actual contribution for need, because the Secretary of State would say, that's all very interesting what the examination panel did, but this is an irrelevant consideration under the policy, full stop. But we have the whole of 420 where she embarks on what are flawed reasons, and which in truth are reasons not seriously defended by the Secretary of State, but just essentially is theoretical. Then when one goes to the question of my only friend went into net zero, and I would have liked to have gone to net zero, but my Lord said give permission. But that was irrelevant to to the 3 grounds of review, because if you look at 140 of the decision letter, the question which is being answered there by the Secretary of State on net zero 5.9 is whether, in granting consent, it would fall into the exception of 1045, i.e. be in breach of domestic law, the Climate Change Act. That was the issue she was addressing there, and I don't say anything more about it because it's not a ground of review, but it is not to be confused, as my learned friend, I respectfully say Mr. Tate, with the consideration which we come to on 1047 and the approach to greenhouse gas. And the position is if one looks at 6.2, she starts with the examination of the examining body. The Secretary of State at 6.7 notes the net zero 2050 doesn't preclude the development, but she's already concluded that, because if it did, it would be a breach of the law. Then she says that, therefore, while the policy in the MP says greenhouse gas emissions from fossil fuel generating states are accepted to be a significant adverse impact, the NPSs also say the Secretary of State does not need to assess them against emission reduction targets, nor does the NPS state that the greenhouse gas emissions are a reason to withhold the grant of consent for such projects. So pausing there in our submission, what does she mean there? She is saying that if you believe Mr. Strawn, she's made it's a policy decision that you just don't give any weight to them. If I'm not sure what Mr. Tate really says about this, but the NPS state that the emissions are a reason to withhold the grant of consent for such projects. I'm not sure if Mr. Tate eventually answered the question posed by my Lord Justice Lindblom, but then it then says it's open to the Secretary of State to depart from the NPS policies. Well, in fact, that's when you come on to look at the sections and give greater weight to greenhouse gas emissions in the context of the Drax. But there's no compelling reason to do so in this instance. That is if one looks, that is 6.3. Going back, this is, because it's not cogently set out. This is her assessment under 1047 from 6.3 to 6.7. So it's not the case that she's then gone on to apply the test. She has, she has, and you have my submissions on where it's a compelling reason to do so in this instance. Don't say that's sophism, because she hasn't set out in policy terms the impact of greenhouse gas emissions and weighed them up against the benefits. She's said that they're not a reason to refuse consent, and then she then looks and sees if there any compelling reason to depart from that in this reason. So that we know under the policy they're shut out of being a reason for refusal if my friends are right. And then when we get, but this is under 1047, it's still shut out unless there's a compelling reason to put them in the balance. So they're kept out of the balance again. So when he concludes at 6.9, on balance, therefore, Secretary of State's consider the benefits of development outweigh its adverse effects, the greenhouse gas emissions haven't been put into that balance. She has put into balance the benefits of the full two gas units and gas storage units. So their benefits of contributing to the need of fossil fuel is included in 6.9.
In 6.7, she says that it's open to her to give greater weight, not to take into account. So one would infer that she has recognised greenhouse gases as being relevant considerations. Maybe she's given them no weight, because greater may be greater than none. And maybe she's given them some weight, but not very much. But the phrasing of the paragraph suggests, doesn't it, that she did consider greenhouse gases to be relevant.
Well, the thing about when you're considering a factor, she clearly has considered them, because in the line before, she says she's considered them against the MPS statement, because she says, nor does the MPS state that greenhouse gas emissions are a reason to withhold consent for such projects. So she's considered them, but she's considered them in the context that this is not a reason for refusal.
Yeah.
So, yes, literally you've considered them, but then she says, well, I mean, give greater weight to the emissions, since it's a bit odd, since she's already said she's precluded under the MPS from them being a reason for refusal. So I don't see how you get into a weighting exercise there. You're not in a weighting exercise in the MPS, if that interpretation is correct. And then she says, give her greater weight than what? She hasn't given them any particular, she's identified in the policy that there are significant harm, but they haven't been given weight in a decision-making process, because she said, the policy says you can't have them as a reason for refusal.
Isn't she simply saying they are a significant adverse impact? They aren't of themselves a reason to withhold the grant of consent.
Yes.
I can give them greater weight than the policy gives them, but I don't see any reason to do so on the facts of this case. Is that what she's saying?
Well, it's not literally what she's saying.
But isn't that a fair summary of what she's saying?
No, it's not, with respect, not. Well, first of all, she's not saying no reason. She's saying no compelling reason. You've got my submissions on that.
Leave that to one side.
You've got that on the departure. But what she's saying is, she's set out, first of all, the MPS also, first thing is she doesn't need to assess them against emissions reductions targets, nor does the emissions are a reason for refusal. It's open to the Secretary of State to do that. And the question is, where is it open? The only place it's open is 1047. Mm-hmm. And what she then says is there's no, but she says to depart from this policy. So I'm not going to repeat the submissions. It's not just compelling case. It's actually applying 1047, as we say, the statutory wording says. You carry out the balancing exercise, and then you go back and decide whether, once you're freed from the restriction of having to decide in accordance with the policy, are you going to depart from the policy? So she hasn't done that. So what we say is you have to you determine whether it's in accordance with the policy. 1043 says you've got to determine, unless you're an exception. 1047 says you balance adverse effects against benefits. Mm-hmm. If the adverse impacts outweigh the benefits, and you are then freed from the obligation to decide in accordance with the policy, and you then have to make a freestanding decision. And that simply is not the way the Secretary of State has approached it. My submission. And she's treated it as if the statute says you have to determine it in accordance with the MPS unless there are compelling reasons to depart from it. And we know from when that sort of phraseology is used in policy, Greenbelt and other very special circumstances, there's all heaps of case law, your lordships know, that there it's said to mean something. Here it's in statute and statutory procedure, it's not policy, and we say it simply hasn't been followed.
Is she not, when you look at these paragraphs as a sequence, undertaking a balance? I mean, she is explicitly doing that, isn't she? From 6.3 onwards.
Well, my lord, no. The balance, what I'm saying is the decision making is all wrong, because her conclusion comes at 6.7. No reason to depart from the policy not to give a greenhouse gas straight away.
She says at 6.9, doesn't she, at the conclusion of that sequence, that her overall conclusion on the planning balance is, etc.
Yes.
And doesn't one read the preceding, 6 or 7 paragraphs back to 6.3 as identifying the elements in the balance, ascribing weight, considering as she does so the examining authorities' weighting, expressing her own weighting to each element, and then coming to that balanced conclusion. And along the way at 6.7 she takes into account greenhouse gas emissions. She doesn't say that they don't go into the balance.
Well, my answer to the submission is no. What we've got on greenhouse gas emissions is the application of the policy at 6.7. It's out, and then 6.8, 6.9. The balancing exercise is, as you see here. Look, 6.8. As far as the negative visual impact assessments are concerned, she deals with those. No other negative issues that weigh against the development. No others.
Yes, but that's because she's already gone through
She's
the others.
discounted greenhouse gas because policy tells her they're not reasons for refusal.
She's discounted greenhouse gas for 2 reasons. Firstly, the policy says, I don't do it for A, B and C. And secondly, and I don't see any other compelling, you don't like the word, reasons for viewing them differently or assessing them differently on the facts of this case.
Yes, so
I could have assessed them differently, she says, but I'm
well,
not going to because I don't see any justification for it.
Well,
And you don't like the word used, but that's
no,
what it's saying.
well, Lord, I don't. But I also don't like the process. My submission is not just the compelling, put that to one side. It's the fact that it's not the finding of the policy and then the balancing of benefits against disbenefits. It's the application of the policy on in the heart of 1047.
Yes, you say you've got to go back to scratch at 1047. You've got to put out of mind the fact that the policy says substantial weight. You've got to forget all of that and say, this is a blank sheet of paper. I'm going to assess benefits and adverse impacts afresh. And if that's right, then you win. But if you're not right on that...
No, I think if I'm not right on my arguments, I lose. Yeah. And even if I'm right on my arguments, I might, it appears, lose as well. Yes. And that's because the important thing to remember, as well as Mrs. Lindblom saying, and we respect that, is that government policy changes can come on as to how you approach that, and it's in that context you're not fettered by a policy made by a different government, another policy that you may not be able to get through Parliament, or what have you. I'm not saying that's always the case, or it isn't, and also that if we're right on the other questions in terms of the look at need, you then can actually assess where you're going. It's not, as I say, it's not expected to be perfect in terms of assessing how much weight to the contribution a particular development project may have. But my learned friend, Mr. Tate, is very anxious on behalf of the Secretary of State to say the bigger the better, sky's the limit. But my learned friend, Mr. Strawn, much of his submission was effectively pushing in that direction. And ultimately, this court, when it decides, if it decides in favour of the approach of the Secretary of State, this is business as usual, and it is ultimately although we're opposed to it, it is the submission of Mr. Strawn, the irredentist position, which is the more fossil fuel, the better. That's the result of this policy. Our submission is you read this policy as a whole and see what it's aiming for. It isn't this result. So far as the my last point is on the EIA. The EIA assessment is a procedural requirement, yes. The regulations and the directive require you to integrate the outcome into the decision-making process. The regulations for infrastructure are for this infrastructure consent. They are not, as Mr. Tate and Mr. Strawn are effectively submitting, something that you just do and forget about. And it's all to do with emissions trading. There is no requirement under emissions trading legislation to have an environmental impact assessment. The regulations here apply to this infrastructure consent. And so our position on that is simply that either you interpret the policy consistently, or when you come to apply 1047, greenhouse gas emissions are back in play, unfettered by policy. And in that way, you achieve compliance with the EIA directive. You can still, of course, Mr. Strawn and Mr. Tate are right. You can have, as we have here, tremendous amounts of greenhouse gas emissions coming out. And as a decision maker, you can ultimately decide that the benefits outweigh the disbenefits. But what you can't do under EIA and 1047 is policy load by policy to remove a matter that must, as a matter of law, be considered. And we've cited in our skeleton argument the case law on that. And Tesco doesn't support the submissions my learned friend was saying. If a matter is something that must be deemed as relevant, it can't, as a matter of policy, be taken out as irrelevant. And there is just the right case, which is in our statutory bundles. I don't take your lordships to it, but your lordship will have the right case, WRIGHT, which makes very clear that. And you need to then read you need to ensure, persistent with also on European level with MAR leasing, that the legislation is effective. And of course, remember when in Tesco, Lord Hoffman was answering Mr. Vandermeer about, and we're talking about material considerations rather than relevant and irrelevant. That was not in the concept of any EU law requirement. So one does need to exercise some degree of caution. But as Mr. Strawn himself said, we're not dealing with material and immaterial considerations. We're dealing with relevant and irrelevant. And my submission is the EIA and the MPS, which clearly refers to the requirement to have an EIA and the regulations
The distinction, isn't there, drawn in some of the cases between things that are relevant in the sense that it's not wrong to take them into account, but equally it's not wrong not to take them into account, and things that are relevant where it would be wrong not to take them into account. There's a sort of inner core of
Credness or something.
Yes, exactly. It's the Cred New Zealand case.
Yes, New Zealand case. These are plainly ones that
We have
you have to take into account.
Obviously material.
Obviously material. Obviously material, and EIA requires you to integrate it into the decision in a development consent order.
Yeah.
My lords, thank you very much. Unless there are any questions.
Thank you very much.
Thank you.
Well, thank you all for your interesting arguments. I was obviously over-generous with my time estimate for this appeal, but all credit to you for getting through it in a day. We will welcome the extra day. It's obviously an important case, so we will reserve our judgments. You will receive drafts in the usual way, which will be your opportunity to correct our spelling and our grammar, but not our reasoning or re-argue the case. We would hope that in the light of the draft judgments you will be able to agree a form of order. If you can't agree a form of order, please make short submissions on it in writing. There will be a hand down in due course. It may be remote, it may be in court, but either way there will be no need for any attendance.
I'm grateful.
Thank you very much.
Thank you.
All rise.